back again. Thank you for sticking with me this far. We're going to really cover two topics in this week's series, and hopefully we'll move a little bit quicker. But by the way, I really don't mind if you speed me up and listen to me with a chipmunk voice. Well, why wouldn't you? So much fun. So what we're going to talk about now is how the profession is regulated and really start touching on what ethics are and what it means to be an ethical lawyer, which will be really key to really getting your head around what we're doing this week. So, ultimately, the sources of professional responsibility really come down to three things: the general law, the statute, and professional rules. Now, professional bodies may also issue guidelines from time to time regarding matters of professional conduct, but ultimately, most of that is detail, and what's important is to understand that to a large extent, the statutes and the professional rules actually codify the law as it is evolved over time to regulate the profession. And so this is why when we keep talking about a profession, we say a profession is regulated by the people who are members of that profession. Clearly, if lawyers were regulated by general law, so common law, it's essentially judges and other lawyers who are making the rules that apply to lawyers. And that over time, most of that has been, or much of that has been codified. As you might remember from contract law and the judgment in Irma Genus, the law, we must be careful to make sure that the law doesn't ossify. And so changes have been made, and where the lawmakers, where parliaments have decided that the law about the regulation of the profession has been too much in the favour of the lawyers, frankly, and not enough in the interests of consumers of legal services, then we've seen that broadening, which is the tension I was really discussing in the previous video. So when we're talking about general law, at its most basic level, we're really talking about the way that the common law governs most incidents of lawyers' relationships with their clients, with the courts, and with third parties. So as between a lawyer and their client, the relationship is really one in contract. And of course, a contract carries with it a duty of care in tort. There may also be fiduciary laws that overlay the lawyer-client relationship, and these impact upon retainers. Retainers are the form of contract that lawyers, well, in fact, clients use to retain the lawyer to act for them. And these, it also impacts what a lawyer can and can't accept, the disclosure that they need to make, and the transactions in which they can engage. So those fiduciary obligations go to putting the best interests of the client ahead of one's own interest. Now, fiduciary obligations are a creature of equity, and equity overlays many of the general law obligations that lawyers have, in particular to their clients. A subset of this could also be confidentiality. Now, confidentiality can be a contractual obligation, a promise given for consideration to keep a piece of information confidential. But in the sense of general law and in the sense of the way that the law applies to lawyers' relationships with their clients, it is part of that fiduciary or equitable duty as well. And that confidentiality obligation forms the main foundation for restraining lawyers from acting against their former clients, and their current clients, which underpins what we call the doctrine of legal professional privilege. And we're going to spend quite a bit of time over the coming weeks, and particularly the second half of this course, talking about legal professional privilege. Now, these slides, if you're just listening and not seeing, you can't necessarily see the slides here, but basically there's a number of links on these slides that you'll be able to open to some of the most important statute law. So After general law, the second source of regulation relating to the legal profession and lawyers will be the statutes. Clearly, they'll vary from state to state, and what I have listed on the slide here is what applies in relation to Victoria, and clearly, particularly when we're looking when we go to the rules, we'll find that they may vary significantly across the states. They'll be pretty consistent in Western Australia, New South Wales and Victoria where the uniform law applies, but there may be what we would think of as regional differences, largely relating to who's responsible for regulating the profession, fees and other things. So in the legal professional rules in Victoria and New South Wales and Western Australia now are subject to the same regulatory framework as the legal profession uniform rules made by the Legal Services Council. And so in Canvas, you'll find that there's quite a lot of information about that. The rulemaking power that's been given to the Legal Services Council is very broad. Uniform rules can be made with respect to any matter that the uniform law requires or permits to be specified in uniform rules, or that is necessary or even convenient to be specified for carrying out or giving effect to the uniform law itself. Now, I spoke a little bit about the uniform law in the longer video that I made earlier, and it's really going to be important that you get a link to that on your computer and be really ready, willing and able to go and look in the uniform law as you consider each of the duties, to go and see how they've been codified and how they apply. So the uniform rules can apply to qualified entities, so that includes Australian legal practitioners, law practices, and even Australian registered foreign lawyers, which we talked a little bit about in the last video as well. Just a quick look here. I think it's also worth noting that some rules apply to barristers and some rules apply to solicitors. So remember, all barristers and all solicitors are Australian lawyers, but not all solicitors are barristers and very few barristers are solicitors. So it's important to think about that difference. And then we end up with the professional rules. So the professional rules, judicially described as an important aspect of the self-regulation of the legal profession. The rules promote the good governance of the profession, and they serve as a standard of conduct in disciplinary proceedings, as a guide for action in specific proceedings, and as a guide for action in specific cases, and also really as a demonstration of the profession's commitment to integrity and to public service. So remember how public service is a key attribute of what it means to be a profession. Well, in many definitions of what it means to be a profession. The courts often resort to professional rules where they think it's appropriate as a way of thinking about what the standard of care is in tort, and as what it is that a reasonable expectation might be of parties where there's been an allegation of a conflict of interest or a breach of confidentiality. So as you will remember from tort and contract, often a judge is basically required to work out, well, what would a reasonable person expect in a set of circumstances. Well, so when we're thinking about the reasonableness of behaviour and whether it was the behaviour of a solicitor or a barrister, an Australian lawyer, is appropriate, then one of the things that the court can use is these professional rules in order to work out what it is that is appropriate or could frame that appropriate or understood behaviour. The rules themselves can't supplant the law as set out in either the general law, so judicial decisions, or provide a private course of action against a lawyer. What they can do is provide guidance. Professional rules also provide guidance, actually, on issues of professional responsibility. They help lawyers to answer questions or resolve dilemmas of that kind. So when you're looking at a particular problem, it's a good idea to see if the rules have considered that problem as you work through problem scenarios moving forward. So ultimately, in Victoria, New South Wales and Western Australia as well, the legal profession is regulated by the Uniform Law. In Victoria and New South Wales, that has been since July 2015, and the law became applicable for Western Australia in July 2022. It's a whole package of legislation, and the following slide I hope will break it down a little bit more. So the purpose of the Uniform Law is set out in the actual law. So LPUL is a commonly used abbreviation, the Legal Profession Uniform Law. And basically Section 1 sets out that essentially it applies in Victoria. Now, it's a little bit odd when you're looking for things because you'll find that the actual statute is published in New South Wales, and the Application Act in Victoria basically forwards you on to the New South Wales legislation. Section 1 also provides for local matters that complement the law. It repeals the old legislation, which of course it would have to do. It included some transitional arrangements, and it made some consequential amendments to other acts. The key really here when you first look at this legislation is to think about what the objectives of the Act are. And this will guide us in understanding what really matters in this legislation. Interstate consistency. It's also about ensuring the competency of lawyers, something we'll talk about quite a bit. It's about protecting consumers and empowering those consumers or those clients to make choices. It's also about finding efficient, effective, targeted and proportionate regulation. So it's trying to get that balance between protecting the users of legal services, but making sure that lawyers can provide legal services without getting bound up in the red tape that makes the compliance with the law just so prohibitive or cost ineffective that ultimately we undo the benefits for consumers. And it's also a co-regulatory framework. So the profession is still involved in regulating itself, but there is a statutory overlay. So the actual regulator is the board and commissioner. The Legal Practice Board and Commissioner. In the Canvas materials, you will find a link to their website, and it's well and truly worth going to have a look at to see how the profession is regulated and what kind of services the Legal Practice Board and Commissioner offer. So the Legal Practice Board element is set up by this legislation, well actually both are, but Section 30 of this legislation really sets out what the objectives of the board are, and the functions of the commissioner are set out separately. So the board is here to ensure that regulation is effective, to maintain professional standards, to protect consumers, to ensure that there's adequate management of trust accounts, and to contribute to the effective administration of the framework. The Commissioner has two core functions. Firstly, to handle complaints, and secondly, an education function. And that, in turn, is also twofold, to educate the profession and to educate the public. So the next thing we need to talk about is what it means to be an ethical lawyer. I've just identified for you a range of sources of regulation, so laws that apply to the conduct of Australian lawyers. But this subject is not only about law, it is about ethics. So what do we mean when we say, or what does it take to be an ethical lawyer? In order to answer that, one of the first things that we really need to decide is, well, what are ethics? I've got a dictionary definition on the slide, and you can see that there are three basic ways of thinking about ethics. We can think about ethics as a system of moral principles. We can think about it as a system of rules, so medical ethics, legal ethics, something like that. Or we can also think about it as a system or a the individual moral preferences that somebody has, a person's individual ethics. And all three of these are going to be relevant as we move forward. Legal ethics come effectively from three places. So there are intrinsic and extrinsic controls as well as the common law. So when we're talking about regulation, we saw general law, statute, and rules. Here we're talking about ethical requirements coming from extrinsic controls, so things like the Uniform Legal Practice law and the rules that are made under it, or equivalents in other jurisdictions. Perhaps other extrinsic controls, though, might be the culture that we work in, the way that other people or outside extrinsic circumstances might impact our behaviours and our choices. Intrinsic controls, so these are the personal values and principles that are really important to an individual. And what's really important to an individual will vary from person to person for a range of different reasons. So I think generally we can talk about things like honesty, courtesy, loyalty, competency. All of those things are likely to be important to most lawyers, but whether it's more important to be competent than to be honest, or more important to be honest than to be courteous, will very much depend on individual flavour. And then, of course, common law. And so the common law is because equity in particular is part of the way that disciplinary, or is a component of disciplinary actions, general law impacts our understanding of what it means to talk about legal ethics. The thing about ethics is that it's rarely about choosing between good and bad. Usually, when we have an ethical dilemma, our choices are between two bads, bad and worse. And there are different flavours of taking ethical approaches. One of my favourite ethicists or philosophers in the area of modern ethics is a woman by the name of Mary Gentile, who's out of Harvard University, I think, who recognises that often when we talk about ethical frameworks, what is really happening is that a person has already made up their mind what they want to do, and then they're using an ethical framework, one of the ones on the screen here in front of you perhaps, to justify a behaviour. And so these kind of ethical frameworks need to be taken with a grain of salt, in my opinion. They can explain behaviours, they can be used to articulate values, but truly ethical lawyers will give voice to their values by really understanding and spending the time of understanding where their values are and being aware of where they may or may not conflict with legal ethics as a set of principles, or of course, applicable law. So at risk of really oversimplifying, there are a couple of different things you need to think about. In the readings, you'll come across this term utilitarianism or utilitarian ethics a number of times. In a nutshell, utilitarian ethics, and the father of whom was Jeremy Bentham, is about calculating the greatest balance of good over harms. So what's the minimum, the easiest way to move forward with the minimum amount of harm to the greatest number of people? Stripped down to its essentials, utilitarianism is essentially a moral principle, and it holds that the morally right course of action in any situation will be the one that produces the greatest balance of benefits for everybody who's affected. It's a pretty popular ethical approach, but there are always difficulties in relying on it as the only method for moral decision making. So the calculation requires that we assign values to the benefits and harms that result from our actions, and we have to compare them with benefits and harms that might result from other actions. in real life, that is really difficult to do. Many of you will have come across the trolley problem at some point. I'll put a link in the materials that will allow you to go to a website to have a go at doing the trolley problem online, but in the context of AI. So you'll be making some decisions about how you would program an autonomous vehicle. And essentially, you will find it very quickly gets very difficult, because you need to make choices about, well, if the option is killing one old person or veering off the road and killing one baby, which one of those things is right? I strongly recommend that you have a go at it as a kind of intellectual exercise to really connect with the feeling that you can have when you're actually exercising ethics as a mathematical construct. What else do I want to say here? One of the greatest difficulties with utilitarianism is that it fails to take account considerations of justice. What is right? So it's easy to imagine instances where a certain course of action would produce great benefits for society, but would be clearly unfair or unjust. Injust? This is particularly prevalent in many political conversations that we have at the moment. So, for example, when we're thinking about refugees, we can think about choices that could be made in relation to refugees, homeless people, addicts perhaps, that maybe they're a small number overall, they're a burden on society, let's just get rid of them all. Now, don't get me wrong, I'm not at all a proponent of that kind of outcome. And in part, even though that might make economic sense, I doubt it does, but let's say it does, then it would clearly be unjust, and that's not fair. Another really important framework is the rights framework. Comes out of work that was done by Immanuel Kant to start off with. Again, looking at exercising rights as opposed to thinking about fairness overall. So as you go through the reading, I think rather than me prattling on and confusing you all at this stage, I would make sure that you're having a good look at the reading, because the readings will bring all of this information together in the context of the legal ethics in particular. And ultimately what I want you to be able to do is go through the exercise that's in the textbooks, which one is it? Christine Parker and Adrian Evans' book. So if you go to Appendix 1 and 2, all available online, give you a kind of survey to do. Now, clearly you're not working as lawyers now, but imagine what you would do in the situations that are put up. Do the little calculation and see which of the approaches, the ethical approaches, actually you sit most comfortably with. I think that's going to be a really important exercise for you for a number of reasons, and it'll inform your understanding and your reactions to the various ethical issues that we come across. Parker and Evans also really, when they're pulling together these 4 ethical ideas that I was just talking about, it's really a question about ultimately asking, what does it mean to be good? What does it mean to be a good person? They've come up with these 4 different ethical types or ethical preferences, each of which refers to the underlying values and purpose that is ascribed to the law that an individual lawyer might have. And they describe the approach that a person who carries those values might take to applying ethical standards. Now, like all of these things, it's a bit like a personality test for lawyers, right? Nobody's going to be 100% one or the other. You might find that you're balancing a couple of different approaches in different ways. But I think the frameworks are really interesting ways for giving us and our colleagues around us language for really being able to articulate the values that we have and why we react to the rules in the way that we do. And so ultimately, what they do with this, and this is why I really want you to take care with this reading, is that they then link those human preferences, individual preferences, to the key ethical frameworks that were really summarised on that very first slide. And I got caught up talking about utilitarianism, but there are definitely a range of other options, all of which are equally important. These are, these are unit, or this unit, I don't know where I came up with the word unit. This course has a key objective of trying to equip you with both information and tools that will help you act ethically. So the idea is that when you enter into practice, you'll have some frameworks for thinking about not only what is the rule, but how does it apply, why does it matter, and what do I need to do in order to assume that I can sit comfortably in my values when this ethical rule or dilemma applies. The different approaches are kind of guides to ensure that you conduct yourself appropriately in the daily practice of being a lawyer. And one of the benefits of studying a subject like this is that you get the opportunity to consider kind of in advance how you would deal with situations, a bit like a fire escape plan, if you will. Another thing that is really valuable, and you'll see some information about it on the canvas, is this idea of the lawyer's compass. It was something that was prepared by the Queensland Law Society probably more than 10 years ago now, and what they were trying to do there is to provide a kind of framework for assisting lawyers who were considering whether or not their conduct is or is not ethical. It provides this framework by outlining the key principles that guide lawyers, and then rather than trying to answer everything, its purpose is to provide a kind of starting point and a context. So you've got this outer ring, which is to consider, well, what's the work that we do as lawyers? Some of it relates to justice, some of it relates to service. Where does it sit? Then as we move in towards the middle, who is it that we owe a duty to? We owe duties to the court, to the client, to our colleagues, and to the community as a whole. Which duty is being affected when this problem comes up? And then really at the heart of the question goes that question of which ethical principles drive the duties that we owe? Propriety, competency, fidelity, or honesty. And these duties will continue to inform the rules as we discuss them later in the course. The very last thing that I want to mention, sorry, that's my dog, is this idea of a hierarchy of lawyers' duties. Now, we're going to start actually with the third one. We're going to start by talking about duties to the client. But essentially, there is this hierarchy that you're going to always have to keep in mind, that we have a duty to obey the law, and that is above and beyond any other duties. Second to that is our duty to the court. And our duty to the court, believe it or not, sits higher than our duty to the client. So whilst the traditional approach, what Parker and Evans would call the adversarial advocate approach, is really very much focused on duty to the client, it can only be successfully operated. So you can only use that as your ethical operating system if you are prepared to set aside duty for the client to duty for the court where there's a conflict. And at the bottom is this idea of duty to others. So basically, we're going to spend a lot of time talking about technology, and we're going to talk about the ethics in association with technology to give you a really good framework for thinking about your own ethics as lawyers as we move forward. We'll come back to lawyers' duties in significantly more detail after sort of around the time of the semester break, I guess. So in weeks 6 and 7, we'll be spending a lot of time on duties to the client. It'll probably eke into week 8, actually, from memory. In week 8, we're going to talk about duties to other practitioners and to third parties, so the community as a whole. We'll then look at duties to the court in week 9, and in week 10 or so we'll start looking at disciplinary proceedings and how that all fits together. But that, I think, my friends, is quite enough for your first week. Questions, concerns, frustrations, compliments if you have them, please send me an email or get on the chat. And of course, you'll meet your tutor in the coming week, and look forward to hearing how the tutes go. Cheers.